say anything, sir?
Yeah, I would like to say I apologize to the victim and their family. I would also like to apologize to my kids and my family as well.
Okay, thank you, sir. All right, do a little bit of housekeeping first. Sir, when you're released from prison, you're going to be on post-release control for 2 to 5 years. Once you're released, if you violate the terms and conditions of that post-release control, you could go back to prison for up to 1/2 of the sentence that I imposed today. You could be charged with a felony called escape for failing to see your parole officer. They could make your supervision harder or longer for you. With regard to your probation violation cases, you are found to be in violation in case number 677-866 and 650-393. Your probation in those matters is terminated. With regard to your credit for time served, you've been in jail on case number 680-880 from May 3rd, 2023. To today's date, 11/30/23. You'll receive credit for those days that you served in jail. Sir, you are going to receive a sentence from Reagan Toke's sentence. We talked about that at your plea on count 4. The Department of Rehabilitation and Corrections may keep you incarcerated beyond the minimum term. I told you you're going to have to get a small number and a big number. Minimum term is the small number. They can keep you longer than the minimum term if they make specified findings rebutting the presumption of release. The Department of Rehabilitation and Corrections will have to hold a hearing pursuant to 2967.271 and find that one or more of the following 3 conditions apply. 1, regardless of your security level, if you violated institutional rules that compromise prison security. Did you want to say something else?
No, we're okay.
Or the safety of staff or inmates, or that involve physical harm or threat of physical harm to staff or inmates, and that those infractions demonstrate a lack of rehabilitation and the offender's behavior demonstrates that you continue to pose a threat to society. Two, you were placed in extended restrictive housing, that's the whole, at any time during the year preceding the hearing. And 3, if you're classified at a security level of 3 or higher. If the release presumption is rebutted, meaning they think you violated some of the rules I just went over, the DRC, Department of Rehabilitation and Corrections, may maintain your incarceration for a reasonable period as specified by the Department of Rehabilitation and Corrections, but it cannot exceed the larger number. The presumption of release applies to the additional period, if they oppose more time, by the DRC, and another hearing must be held to further extend the incarceration. You, however, must be released at the expiration of the maximum term and then will be subject to PRC, which we've already gone over. Your fines, fees, and costs will be waived. So the primary purposes and principles of sentencing are that I am to punish the offender and protect the public from future crime by the offender and others, using what the law says are minimum sanctions that the court determines accomplishes the purposes without imposing an unnecessary burden on state or local government resources. The primary principles are always to consider the need for incapacitation, deterrence, rehabilitation, and restitution. And the sentence should be commensurate with and not demeaning to the seriousness of the offender's conduct and its impact on the victim and consistent with sentences for similar crimes by similar offenders. In considering whether the offender's conduct is more serious, under 2929.12b, I have to consider whether the injury was exacerbated by the victim's physical or mental age or condition, which I do not find that it was. I do find that the victim suffered serious physical, psychological, and economic harm in this matter. I believe that the victim and the offender, did they have some type of friendship or relationship? They knew each other.
That's correct.
Okay. I do find that the offender's relationship with the victim facilitated the offense. I do not find any of the other considerations apply. In determining whether Mr. Edmond-Geiger's conduct is less serious, I do not find that the victim induced or facilitated the offense. I do not find that the offender acted under a strong provocation. I do not find that the offender did not cause or expect to cause physical harm to the persons, meaning the victim. I do not find that substantial grounds exist to mitigate Mr. Edmond-Geiger's conduct. Well, I find that there are substantial grounds to show how he got to the place he ended up at on May 2nd. And much of that is outlined in the court psychiatric clinic reports that I have, the pre-sentence report, and much more was outlined by Mr. Radigan when he spoke. I do not find that those mitigating factors constitute a defense to the behavior that happened here. Whether recidivism is more likely, I do find that Mr. Edmond-Geiger was on community control when this happened. He does have a history of criminal convictions, though I will note that those convictions are not convictions of violence. Whether recidivism is less likely, I do not find he has any prior juvenile delinquency adjudications. He has one prior felony before these felonies in 2012. Everything else was misdemeanors. There could be an argument that he has not led a law-abiding life for a significant number of years. Whether the offense was committed under circumstances unlikely to reoccur, that is an unknown factor to the court. I do not know the answer to that. With regard to consecutive sentences, the presumption is that concurrent terms will be imposed with the discretion to impose consecutive sentences if necessary to protect the public or punish the offender, and not disproportionate, and the court has to make findings in order to do that. I am going to impose a consecutive sentence. The law wants the court to take into consideration similar crimes, similar offenses. I've never seen an offense like this in my time on the bench. I've had hundreds of kidnappings, probably hundreds of felonious assaults. Never have I seen anything to this magnitude. In fact, most of the kidnappings I think are just an extra charge that don't make much sense in the context of the cases that I've seen. This, in fact, indicates a kidnapping that truly is at the higher and more serious end of the spectrum, as well as the felonious assault. I do find that the victim suffered substantial and serious physical harm and mental harm. I find that these crimes were committed while Mr. Edmond-Geiger was under sanction. He was on probation with me. I do find that the harm in this matter is so great or unusual that a single term does not adequately reflect the seriousness of the conduct. Much of that has been outlined. I don't need to go over that again. It's been outlined by Mr. Bringman, and also with regard to the victim statement that she made in court. I make those two findings. Without this case, I could not find that he would have committed an offense of this nature. It is out of character for what he has had on his record. So I am going to impose a consecutive sentence with regard to counts 2 and 4. With regard to counts 5 and 6, the sentence on count 5 is 30 months. The sentence on count 6 is 30 months. Counts 5 and 6 will run concurrent to each other, and the sentences that were imposed in counts 5 and 6 will run concurrent to the sentences that are going to be imposed in counts 2 and 4. All right, count 2, 8 years. Count 4, 8 years is the minimum sentence to impose. 12 years is the maximum. Those counts are going to run consecutive. You have 16 years to 20 years to serve. He's ordered remanded and transported.